Hi, my name is Michael Zink. I'm a partner at the firm of Starr, Bejgiert, Zink and Rowells in Chicago. Today I'm going to discuss some of the basics of Landlord Tenant law, especially with respect to the Forcible Entry and Detainer Act in Illinois. Much of Landlord Tenant law in Illinois falls under the provisions of the Forcible Entry and Detainer Act. I'll call it, for the purposes of our video, the Forcible Act, but essentially these are the proceedings in which evictions occur. There's a great deal of misunderstanding of what happens in these eviction proceedings. First of all, the Forcible Act must be strictly construed. It is held in derogation of common law. So what that means is what the Forcible Act states must be strictly construed by the judges and by the litigants before the judge. One of the most common misconceptions is that landlords can sue for something other than rent. In no less than 5 provisions in the Forcible Act does it state that the landlord or the plaintiff can only pursue claims for rent. So in other words, landlords or any other parties who bring these actions cannot sue for personal injury or physical damage to the property. Those would be matters that they would have to file separately. Likewise, a defendant, usually a tenant, cannot file counterclaims that seek monetary relief in almost any circumstance. The few exceptions in which monetary relief is allowed for a tenant or a defendant to claim is if it's a claim of retaliation or if it is a claim of a violation of the implied warranty of habitability, essentially claiming that the landlord committed violations of the conditions of the premises that rendered it uninhabitable. So the common example that I give to people is just like a landlord is not allowed to go after a tenant for any bodily injury that he may claim that the tenant caused to him. Just like he cannot do that, the tenant cannot pursue any claims against the landlord. These actions under the Forcible Act are restricted to rent and rent only. No other provisions, no other laws allow any party to bring claims other than a rent. The landlord obviously also seeks a claim for possession. These are twofold claims. And the claim for possession essentially is the landlord claiming that he is entitled to possession, that he has a superior right to possession. What that means essentially is that, again, the landlord cannot claim anything else other than a possessory right in equity. The tenant cannot raise defenses with respect to title. Issues of title are not relevant or not germane under the distinctive purposes of the Act. And so the landlord must only focus on his or her right to possession, and then it has to be a superior right to possession over the defendant. The Forcible Entry and Detainer Act also sets forth various notices and demands that a plaintiff has to serve on a defendant before a case is filed. First of all, that notice has to be very strictly construed with the Act. It has to have the address of the property. One common mistake is leaving out a unit number or an apartment number. That must be included in the notice, or it is grounds for dismissal if it gets to court. The notice has to be served typically on the defendant. It cannot be stuffed in a mailbox or slid under a door, for example. It must be served on the tenant or the defendant, or it can also be served on somebody aged 13 or older who resides at the property. The Act does allow for landlords to send that by certified mail. However, as a practical matter, many defendants and tenants do not respond to that and do not pick it up, and so it is not advisable to do it that way. The various notices under the Forcible Act, one of the most common that we see are the 5-day notices, essentially claiming that a tenant owes rent. It must include the address in its entirety, as I stated before. It must also indicate how much rent is due. It is essentially a final 5-day period for the tenant to pay whatever is due. Other notices include a 10-day notice. Those are for breaches other than rent. And a 30-day notice, which is essentially a notice for somebody who is a month-to-month tenant and the landlord is terminating the tenancy. Demands for immediate possession are also allowed. Those typically are common when there is no landlord-tenant relationship, often with a family dispute. For more information on basics of landlord-tenant law, please view my full presentation recorded during the 3rd Annual Elder Law Boot Camp and available in the ISBA online CLE archive.